All right. First, we have a business before the Honorable Chief Judge and Associate Judges now sitting en banc for the District of Columbia Court of Appeals. Draw near and give your attention. God sends the United States and this honorable court. This honorable court now in session. Please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. This morning we are sitting en banc to hear the case of Nicholas CZAJKA, and I hope you'll correct the pronunciation, versus HOLT Graphics Art Incorporated. I will note that Judge Corey Beckwith is participating in the en banc decision, but is unable to join us for the argument this morning, so she will be listening to it and participate in the deliberations. I'm joined this morning on my far right by Judge V.J. Schenker, Judge Josh Steele, Judge Kate Easterly, on my left by Judge Roy McLeese and by Judge John Howard. The en banc case before us this morning presents an issue of statutory interpretation, whether the 12-year enforcement period for a foreign judgment in DC pursuant to the DC Uniform Enforcement of Foreign Judgments Act, as prescribed in our DC Code 15-101A, begins to run when the foreign judgment is entered in the original court or when the foreign judgment is filed in DC. And for this case, that means whether the enforcement period for HGA, HOLT Graphics Arts, judgment began to run in November of 2001 when it was entered in California, which would render it untimely for the purposes of this case, or in November of 2006 when it was filed in DC, rendering it a timely action. This case was heard first by the original three-judge panel consisting of Judge Kate Easterly, Judge Roy McLeese, and Judge Josh Steele, and the majority affirmed the trial court's denial of the motion to dismiss the matter, stating that the 12-year statutory enforcement period began to run in 2006 when HGA filed the foreign judgment in DC. The dissent argued that the 12-year enforcement period began to run in 2001 when the foreign judgment was entered in the original jurisdiction. With that, I understand we have an amicus party, DC Land Title Association, and they will be participating in argument, and perhaps the petitioner can tell us how you all plan to divide your time.
Good morning, Your Honor. May it please the court, I'm David Cox with Jackson Campbell here representing the appellant. I have agreed with Mr. Russo and I've filed a motion with the court where I've allocated 8 minutes of my time to Mr. Russo to argue on behalf of the DC Land Title Association. I'm hoping he won't use up all those minutes, so I'll have a few more minutes to save.
And I'll just note for all the parties that the matter was briefed below. We have the opinions of the majority and dissent, as well as the briefs on in furtherance of the petition for en banc. And so the parties should not feel that they have to use all 45 minutes of their time. So.
Thank you, Your Honor. And you're right. This matter has been thoroughly briefed at least twice before this court. So I understand that we don't want to cover the same territory if we can possibly avoid it. But as the court noted, the principal issue here is the question of when did that statute of limitations for the foreign judgment begin to run? And obviously it's our position that that 12-year statute of limitations began to run when enforcement could have first been issued in California in 2001.
And the language you're referring to, since we're looking at how these statutes interplay, if you could, as you're arguing, just note where you're which statutes you're relying on.
Understood. In fact, thank you, Your Honor, because it's critical that we differentiate at the very outset. There are two different statutes that relate to the particular topic. Creditors have two options under the District of Columbia law. One is they can pursue a simple administrative filing, which is what happened in this case, where they simply file with the court a certified copy of the judgment. And then from that point forward, it remains a California judgment. It never became a DC judgment. And I think that distinction for our purposes is fairly critical. There is a second method by which creditors may enforce foreign judgments, and that's by filing a separate civil action with all the proper notice, proper service of the complaint, and allowing the judgment defendant here in the District of Columbia to then appear, defend, argue, whatever course it may choose to take. But that is not the course that was followed in this case by this particular creditor. If the second course had been followed, then it would have been a DC judgment, and we wouldn't be here today.
Can I just ask a question about the practicalities of this? So you say, well, in the more protracted process, you get notice and sort of process in a court proceeding. But to what extent is that not true under the more streamlined process? If a foreign judgment is registered against somebody, isn't it a requirement that they be notified of that? And don't they have the option to challenge that judgment and avail themselves of all processes available?
No, that is not clear from the statute, Your Honor. It is clear that they're supposed to get a copy of the notice that's submitted, but I don't believe it's the equivalent of the civil action at all.
It's certainly not the equivalent of it, but if they have notice that the judgment has been registered, then they could bring their own action if they wanted to.
They could. I mean, that's not what the statute outlines. The burden is really on the creditor to choose a course of action, not on the debtor.
Well, the statute says that you get the same defenses. So the defense could be an offense, right? Of filing your own suit to challenge the filed foreign judgment, or it could be to wait for some sort of enforcement on the filed foreign judgment. And at that point, raise your defenses, right? Either one would work.
Either one would work. I mean, that's hypothetical because that's not what happened here, but yes, I think
we're not tied to the facts. We're trying to interpret the statute as it's written, or interpret several statutes as they're written, right? We're looking at the statute that allows for foreign judgments to be filed, which is sort of the streamlined approach to recognizing foreign judgments. And then we're also looking at the statute of limitations statute to see how that maps on or interacts with the Filed Foreign Judgments Act.
And
so to the extent that we want to look at the facts of this case, that doesn't take us very far, right? We need to focus on the statutes.
And the statute, as I say, the DC Council enacted two separate statutes to deal with two separate situations. One was under the Uniform Act. If you just want to use the streamlined approach as a creditor, that's your prerogative.
Mr. Cox, what basis in either of the statutes leads you to conclude that the streamlined process does not render it a DC judgment, whereas the common law process does convert it to a DC judgment?
I think the statute actually is very clear on that it never becomes a DC.
What, could you point me to the provision or the statutory language?
I think it's either, if I may. I think if we look at 352, I'm sorry, DC Code 15352 and 353 and 354 and 356, when you read those statutes together, they make it very clear that the foreign judgment.
I know, I just want you to, I guess I never saw that clearly in the provision. So if there's a piece of one that you want to call out that underscores why you think under one route, it doesn't become domesticated for a DC judgment, but under another, the civil.
Well, section 351 defines what a foreign judgment is.
Mhm.
And it means any judgment, decree, or order of a court of the United States or any other court that is entitled to full faith and credit in the district. And-
Counsel, help us understand how that is not a distinction without a meaning, because 13-352 goes on to say a foreign judgment filed with the clerk shall have the same effect and be subject to the same procedures, defenses or proceedings for reopening, et cetera, and so forth. If it takes on all the characteristics of a DC judgment, why does it make a difference that we don't call it a DC judgment and we call it a foreign judgment instead?
It certainly makes a difference for purposes of our case as far as when the statute of limitations began to run. But I think otherwise, if they're the same, then the statute is superfluous, right?
Well, but several other jurisdictions that we know are aware of that have adopted the revised Unified Enforcement of Foreign Judgments Act have adopted it alongside of their other civil enforcement common law procedures that were in existence, similar to what our statute has done here. And in as far as I know, in many, if not most of those jurisdictions, the interpretation is that under the statute or the streamlined process, the judgment becomes domesticated and a judgment of that jurisdiction, and the time begins to run from the date that it's domesticated in the foreign jurisdiction.
Actually, I think there's ample case law from other states where they recognize that there is a difference between the two situations, and that the streamlined approach remains a true foreign judgment of the state that rendered that judgment. In the states that also have a comparable provision to the DC code that allows the creditor to file a formal civil action, issue a summons and complaint, etc., then that's the circumstance under which it truly becomes a judgment of that state. So I think
But
that's
does the fact that, sorry to interrupt over here.
Oh, sorry.
Does the fact that it does not become a DC judgment really answer the question? I mean, we're still looking at when execution what date starts the execution clock, right? And so even if you still have a foreign judgment, DC is naturally concerned with assets in DC. And so why would DC be interested in when a foreign jurisdiction might have allowed execution potentially on assets held in that foreign jurisdiction?
Well, I would suggest that DC is also concerned that there's only a 12-year period in which that can be done. So it still begs the question of when does that statute of limitations begin to run? And that's why it makes a difference. If it's a foreign judgment and you could have issued process on that judgment to begin enforcement.
But you couldn't have with respect to DC property until you recorded it here in DC, right?
Right. And then most creditors, if they're going to pursue that route, they promptly record it in the District of Columbia, usually under the streamlined approach.
Counsel, did they not promptly record it here? The judgment debtor, as my understanding, looking at the papers, didn't have the property until 2004.
Right, but they didn't record anything here in the District of Columbia until 2006. If I'm suing somebody, let's assume I'm out in Virginia and I'm suing somebody who lives in DC, I'm going to go ahead and record that judgment in the District of Columbia. I don't know what assets they may have. I haven't done a title search. I haven't done a judgment or lien search. I don't know what they may have, but I want my judgment to be there in time or to then apply immediately to whatever asset they may own in the District of Columbia.
Right,
So-
but that could apply to all 50 states and territories. I mean, I guess there's no indication here. I know one of the concerns that cited and identified in your brief and the amicus is the notion that allowing the time to run from the date the judgment is domesticated in DC may encourage creditors to sleep on their rights. I don't see any evidence or indication of that here, other than the time it took. And in many instances where debtors are not eager to pay the debt immediately or acquire assets over a period of time that may not have been in place initially, it's not, that's the reason that we have an extended period of time in most jurisdictions for creditors to be able to execute on and collect on the debt that they have duly been adjudged to be owed. So,
Well, as you noted during your own research, states vary tremendously over that period of time. Some are as short as 7 or 8 years. Virginia is one of the examples of a longer period, 20 years, within which to enforce any judgment that's been properly recorded and indexed. So yeah, I think in our particular case, the question is, when you look at the language of our statute, particularly 501, with respect to, when could process have first been issued? That language is there for a reason.
Can I
Can
ask
we
you what you
just,
think it
I'm
means?
sorry, I wanted to just jump in. Can we look at how it works in DC? Right, say this 2001 judgment had been originally a DC judgment. And as Judge Howard points out, the property in this case wasn't acquired until 2004, right? So say someone had a DC judgment and then the property is acquired in 2004, right? The timing of the enforcement of the judgment would date from the 2001 judgment, assuming, right, that the judgment had been recorded. So say you've got the 2001 DC judgment, the property in DC is acquired in 2004, and then the judgment is recorded in 2005. Under DC law, the 12 years would still run from 2001, correct?
Correct.
Not 2005,
No,
the
we have-
date that it was recorded with the
Correct.
recorder,
Exactly,
right?
because we don't know when a debtor might obtain a particular asset, and we probably shouldn't focus exclusively on the real property, because we don't know what other assets the judgment debtor
Right.
may have had.
But our statute of limitations dates from the date that the court issues a judgment, which is an event that the creditor has no control over, right? Unlike recordation or filing, which is a date that the creditor has total control over.
Correct.
Okay.
Can I ask you
Thank
another
you.
question about how you interpret the phrase when an execution might first be issued thereon? And to take a simpler example, again, imagine a entirely DC situation. So if I get a judgment in DC, so it's rendered in DC, which is the first predicate, for the statute of limitations in the simple setting where we're in DC under 15101 and not having to rely on foreign judgment provisions. So it's rendered in DC. The question is when an execution might be first issued thereon. Do you agree? Here's my abstract question. I'll give you a hypothetical to explore it. That when an execution might first be issued thereon means when an execution might first be issued thereon in the District of Columbia. That's what that means. And let me give you the hypothetical. So in DC, as I understand the rules, the day I get a judgment, so a judgment is rendered in DC, execution can't issue thereon that day. I have to wait at least 30 days before execution can issue thereon.
That is correct.
And so in DC, in the regular situation, is it 12 years plus 30 days because I couldn't issue judgment in DC on that judgment? I couldn't issue an execution on it for 30 days, and then I would get 12 years plus the 30 days that is required before I can start executing on the judgment. Is that how it works in DC?
It is, and I think that's a fair interpretation.
And so let's say Virginia doesn't have a similar requirement that you wait 30 days before you get an execution. So I get my judgment in DC, and I could have gone to, I could register it immediately in Virginia and execute immediately in Virginia, assume that's true. Does the statute of limitations in DC with respect to my DC judgment run, is it 12 years plus 30 days? Because it is when execution could be issued upon it in DC. Or is it just 12 years? Because there's somewhere in the world where somewhere in the United States where I could have executed judgment on it immediately.
It's a great question. I would suggest that, you do get the extra 30 days because you were precluded by DC law.
And if that's right, I think it follows that you're saying that what this phrase means here in the simple situation, at least of DC, is that what that means is when an execution might first be issued thereon in the District of Columbia.
Correct. For purposes of a DC judgment, and yes. I think
And
that's
it
correct.
remains to be seen what that might mean if you add in the complexities of a foreign judgment. But I just wanted to see whether you agreed or don't agree that the phrase, at least in the ordinary situation of an entirely DC situation, it is when an execution might first be issued thereon in the District of Columbia.
And our research showed that California has no such 30-day delay. In other words, once the judgment's entered in California, you could begin enforcement.
And similarly, you agree that in order for this provision to be triggered, the judgment at issue needs to have been rendered in the District of Columbia, because it's not like this is a provision that by its terms, independent of the RUEFJA, applied to impose a statute of limitations with respect to judgments that are entered elsewhere. It must be rendered. So the things that have to happen are A, it has to be rendered in DC in a simple situation where it's only DC, and then B, execution has to be execution must be able to be issued thereon in DC.
Counsel, in your view, does the 12 years from the DC statute displace the 10-year statute of limitations in the California?
No, but I've given that some thought. We have some interesting facts here, as you know, because ironically, the California judgment by its own terms expired in 2011. Right? There's no evidence in the record that the California judgment on which this judgment is predicated was ever renewed.
So you feel like if I have a foreign judgment I've domesticated in DC, I need to keep the judgment alive in the foreign jurisdiction and in DC?
Actually, that's what we do in practice. I mean, just to be on the safe side, is we don't allow the underlying judgment to expire, because if nothing else, you're then precluded from filing it anywhere else. So
help me with a procedural hypothetical. This, let's say it expired in 2011 and the renewal was filed in 2012 in DC. It's now 11 years in DC or 11 years in DC, 11 years in California. The California judgment's expired. Procedurally, how would you deal with that in that situation here?
yeah, like again, I said, I think the important thing is to keep the California judgment alive. So you then have a predicate basis on which to have a foreign judgment being enforced. But here we don't dispute the fact that, given the fact that it was domesticated in DC, you have a 12-year statute of limitations in DC.
I understand. My hypothetical is the judgment has expired in California and they're now trying to domesticate it in DC within the 12 years. Procedurally in DC court, or in DC, once that's been registered, what would you do for your client to deal with that?
I would keep the underlying California judgment intact. I would not have allowed it to expire as it did in this case. Number two, DC has a procedure by which you can renew that judgment. And I think that's what was pursued here, was to renew whatever was domesticated in DC for another.
You're representing the debtor now. The debtor gets the notice that this judgment has been filed and they say, oh crap, let me go talk to an attorney. They give it to you and you see, okay, this is 11 years. In California, this is expired. What do you do on behalf of the debtor at that point, or what would be your instinct?
My instinct would be to file an action to challenge any effort to renew that judgment here in the District of Columbia, because I would say the underlying judgment on which this judgment was predicated, the earlier judgment, has now expired. There's nothing.
And there's
to
no
renew.
full faith and credit interest
Right.
in pursuing that judgment here. Can I just ask you a question? We keep talking about domesticated foreign judgments. Is that a statutory term?
No.
Is that term
That's a
helpful?
term we
Is that
use.
term helpful, right? I mean, because there's nothing in the statute that talks about domesticated judgments. It's either you go the common law route of getting a judgment on a judgment, you get a new judgment that's a DC judgment, or you have a filed foreign judgment under 15.
That's true. That
352.
that phrase is one that local practitioners use to just differentiate between an original DC judgment and one that has come in from a foreign jurisdiction.
Right, but it sort of loses the precision that maybe we need when we're interpreting the statute if we refer to domesticated foreign
Right,
judgments.
fair enough. So in the example you were asking me, Judge Howard, it's, you have this foreign judgment that is now expired by 2012. When the situation is presented, if it were up to me, I'd go in and challenge any effort to try and enforce that and say, no, as you say, the full faith and credit concerns have been addressed. California's concerns have been addressed. We honored their judgment for the period of time that California permits. And any effort now to enforce in the District of Columbia after it is expired should be challengeable.
But you would say that we haven't given you a lot of clear guidance on what the specific procedural mechanism would be when you get that notice of the registration of the foreign judgment.
That is correct.
Can I ask a practical question? Part of, I guess, underlying this question is who cares? Who cares about what the process is? Because if it's true that in registering a foreign judgment in 2006, you're only left a 2001 California judgment, you register it in DC in 2006, giving you, instead of the normal 12 years in DC to enforce that judgment, now you're down to 7 years. As a creditor, and we pretty freely revive those judgments, why wouldn't you just file a motion to revive the judgment then and get a new 12 years?
I think that's what they did. They didn't do it timely, but that's what they actually did here.
Oh, right. I mean, they didn't do it timely under your calculation of the statute of limitations. They did under their depending on when the 12 years begins to run. But I'm saying, if I'm a creditor and I don't get the full new 12 years under the Streamlined Act, why wouldn't I just file the motion immediately upon registering the foreign judgment to get a new 12 years? You could get it that way, right?
Well, if you were that interested in it as the creditor, you wouldn't have done the streamlined approach to begin with, right? You would have filed a new civil action. You would have brought the judgment to the attention of the Superior Court, District of Columbia. You would have given, there would have been a summons and complaint.
Why? I mean, the filing a motion for revival seems a lot simpler.
Well, it is, but I'm just going back to the, why were they short 4 years, 5 years? It's because they went to the streamlined approach as opposed to getting an actual DC judgment within a civil action. And
what I'm positing is they can get the 12 years, the full 12 years through the streamlined process under your approach, so long as it's accompanied by a motion for revival. That will give them the new 12 years.
oh, I see what you're saying.
And why not do that?
Even in 2006.
Correct.
We
There's sort of two worlds.
We-
In HGA's world, by registering that judgment in DC, they get 12 years. In your world, they only get 7 years by registering the judgment, unless they also file an accompanying motion to revive, in which case then they get 12 years. So, I mean, are what we talking about in this case, is it that little procedural rigmarole that we want to impose on creditors to get them to the exact same end? And what's the value of doing that?
I don't think it is just merely procedural, and I don't think any creditor would pursue that course. I think the way that it would work is, if you record a judgment in the District of Columbia, whether it's from California or wherever it's from, you then calendar it, right? You calendar for when do I need to take action? It would be great to have even sharper guidance for everybody to know, when that needs to be done. But of course, they could have obviated the need to even get into that issue had they pursued the second part of the statute, which is if you want to have a true DC judgment, then do it the right way.
I thought we just established that the revival route was going to be a much easier way to get the full 12 years though. So why, I mean, I can see you saying, well, people wouldn't do it that way. We haven't thought of it that way. Why wouldn't some creative, somebody's going to figure that out under I've figured it out. This is not my area of expertise. Why isn't everybody gonna figure that out and just start inundating the DC courts with motions to revive alongside the registrations?
Well, I'm not sure why anybody would do that at that time, because why would they file a motion to revive a judgment that they just finally had entered in 2006?
Because they'd prefer to have 12 years to 7.
Well, if that's the decision of the creditor, they could have done it a different way, right?
A much more complicated way than the way I've just laid out, yeah.
I don't know how complicated it
Isn't,
is. to
I
file
mean,
a civil action.
isn't the answer that they could, they could, and if they do, then that promotes the objective that our statute of limitations statute seems to promote, which is that we don't want people to sit on their hands, right? And so they could either do it right when they file, right? And that would be fine. Or they could say, well, I don't need to do it now because I think that I'm going to be, I've got 5 more years or 7 more years. That's plenty of time. I'll be able to get this done. And then if they don't, and as you say, they've got it calendared of when the judgment's going to expire, then they take that second step a little bit later, right? And maybe the debtor will respond and maybe they won't, right? But it seems like the motion for revival is a whole lot less work than actually initiating a whole new complaint, right? And getting a judgment on a judgment.
Yes, although well, I'm not sure how a Superior Court judge would react when a judgment has just been sorry, almost said domesticated. It's been registered here in the District of Columbia. Why a creditor would then be filing a motion to revive to get now the full 12 years? Maybe, I suppose that's one way of.
I mean,
doing
in
it.
our hypothetical world, this court has clarified that the statute of limitations runs from the date of the foreign judgment, not from the date of filing. So I think it would make sense to the Superior Court.
Oh, I
judge.
think if that was clarified by this court, that is the operative starting date, is the date on which process could have issued in the state that rendered the original judgment. You'll find creditors who may be as clever as you suggest, who will say, you know what, all right, now I know that definitively. Now I've got options, right? I can file a motion as you suggest. I can file a separate complaint as the statute allows.
Can I ask you about the second complaint route? Because it's a common theme of the discussion that going the common law route that's preserved by 15356 is more cumbersome. And that was definitely part of the thinking in enacting the model or creating the model RUFJ. And so that seems to be a line of thinking, but I will confess I'm a little unsure about concretely the ways in which it is more cumbersome, given that 352 says that once the judgment is filed, the clerk will give notice to the debtor that the judgment has been filed, and then that filed foreign judgment, which may or may not become a DC judgment, and also in some sense of that phrase, is subject to the same procedures, defenses, or proceedings for reopening, vacating, or staying a judgment of Superior Court. So it seems as though as soon as that's filed, any defense that the creditor might have is open for business. So I get the idea that you don't have to file a complaint. So there's that. And the burden is really in a way more on the creditor than the debtor. So I see those two differences. But if so a creditor could wait, or a creditor could start asserting defenses. If the creditor chooses to start asserting defenses, then those asserted defenses seem like they will be subject to the same procedures, which I assume means discovery and whatever other procedures you would think would apply in an original action. So other than you don't have to file a complaint, and other that the burden is on that it's possible to just wait rather than litigating right away, and the burden is at least on the creditor to raise defenses. So I get those 3 points. Are there other ways in which going the 356 route is materially different, more cumbersome, or the like, or is that really the universe that occurs to you also?
That is really the universe of the quote burden unquote on the creditor if it elects to go 356 is all right. Now they might have to defend the fact that they got a foreign judgment, right? In other words, the debtor, I obviously can't speak for all debtors, but a debtor who's living here may not really care that California has entered some judgment. They may be thinking, well, how does that court have jurisdiction over me? I'm not going to worry about it. And that probably happens with some regularity. But if the creditor chooses to then go to the common law alternative statutory route, then, the defendant may say, okay, I didn't bother to go to California. I didn't travel 2,500 miles to go defend myself in a $9,000 case. But if you're going to come here and you're going to sue me here, yeah, I'll mount a defense. And it may be that, the contract was void, it was forged, whatever the defenses may be that a debtor might have available. But the way the statute works, it definitely is.
You think
keeping the
that
burden
proceeding
on
will give the debtor a second bite at the apple on defenses?
Well, arguably, except that if it was fully litigated in California, I think it's going to be difficult for the debtor to have much of a chance here in the District of Columbia, since it's already been fully litigated. That isn't what happened, I don't think, here. Here, the person just didn't show up, but that's not unusual. If you're a debtor and you're sued in Hawaii, or you're a resident of the District of Columbia or the state of Washington, you're not going to be traveling there probably to go defend yourself in what starts off as a very simple contract action.
The debtor here was an attorney, right? And
I
likely had some.
don't know that. I think that's correct. I don't know that.
And would you also agree with the premise that in going that common law route and filing that suit, if I'm a creditor, I'm also potentially going against my interest in forcing that debtor to burn out resources from their assets that I could have potentially gone to get?
Well, maybe, but that's really the debtor's call, in the sense of, do I choose to defend the action or just go ahead and defend, but compromise and pay something? There are a range of options that are open if in fact a civil action has been filed.
Counsel, if, going back to Judge Howard's hypothetical, if we have a California judgment, we're in year 11, so expired in California. The debtor who resides in the district doesn't acquire property in the district until year 11. Is the creditor out of luck at that point? Or or they could revive it in California and then register it here?
Well, if your hypothetical excludes the 2006 recording here, yes, then the California judgment has expired. And there's nothing that more the creditor can do except file a new action. If they have new claims, they can file. But if that judgment in California has expired, it was never registered here in DC, then that judgment is no longer enforceable. And the statute makes that very clear. You can't renew a judgment that's expired.
And that's seemingly entirely consistent with full faith and credit principles, which is what 15.352 was enacted to fulfill.
Correct. So we've honored exactly what was supposed to happen, right? If there was a judgment, creditor didn't take any action or wasn't able to collect on it, it's now just expired by its own terms. That happens all the time.
Can you just remind me where it makes it very clear that if it's expired in the foreign jurisdiction, you can't register it?
No, actually, I'm sorry. If that's what I said, I'm to correct myself. I didn't say you couldn't try and file an expired judgment here in the District of Columbia. I think as a practical matter, that would probably at least initially get recorded and registered here in the District of Columbia. The clerk's not going to make a determination, oh, gee, the statute of limitations around California, I'm not going to honor this. They're going to accept the filing, the 2-page filing, your $25 filing fee or whatever it is. And now it will be a record that there is a judgment. Now it's going to be up to somebody to challenge that. But
And what's the part of the statute that would tell that somebody that you don't get to enforce that California judgment if it's filed after 10 years? I think there is an answer to this. I just can't recall what it is.
Right.
If it's filed in year 11, you don't have another year because, if you looked at 352, it says a foreign judgment filed with the clerk shall have the same effect and be subject to the same, et cetera, et cetera. It would seem you could argue, well, there's a 12-year statute of limitations in DC. It's still a foreign judgment. It was issued within the last 12 years, and therefore I can enforce it. Unless something I don't think it's in the definition of foreign judgment that says it needs to be active, but it might be, is it somewhere in the statute?
I don't think it is. I'll be glad to look.
Well, isn't it in the definition, because a foreign judgment is by definition one that is
Still one.
entitled to full faith and credit, and an expired judgment is not entitled to full faith and credit. I mean, maybe that's not been said before by our court, but I have a hard time understanding why an expired judgment would be entitled to full
Correct.
faith and credit.
I agree with Your Honor. I just can't point you to a specific statutory reference that says you cannot register a judgment in DC even if it's expired. And you know, that's, I think actually it could happen. I see I'm down to 1 minute. If I may, I'd like to reserve the rest of my time available, except for the 8 minutes I've allocated to Mr. Russo, for him to address the title company's concerns about how the statute is interpreted and what message we want to send to the public. Thank you.
Thank you.
May it please the court, and thank you for this opportunity. I'll try to be brief. My name is Michael Russo. I represent the amicus. The DC Land Title Association is a trade association made up of title insurance underwriters, settlement companies, and associate members who are attorneys, lenders, and surveyors. Our stated goal is to facilitate the settlement of property and in the district. The way we do that, in a large part, is when a title comes in, we search the title, we find defects such as a foreign judgment. Then we don't just reject the title in our underwriting, we see if those defects can be investigated. And if we can do something to clear that title and make it marketable in the district. Some of those things we do is we contact judgment creditors. We say, is this still owed? We'll contact the local state jurisdiction to see if perhaps the judgment was released in the trial jurisdiction. Our goal, again, is to clear this title so that we can issue a policy of insurance, because frankly, practically, if a policy of insurance can't be issued, a lender will not lend money for the acquisition of that property in the district. So we need, and we ask for, if it's possible, a guidance and a definitive certainty.
Well, in that vein, Mr. Russo, I understand one of your arguments in the amicus brief being that the majority panel decision creates less certainty by having the clock run from the date of filing under the Uniform Enforcement of Judgments Act versus the date that the judgment was entered in the foreign jurisdiction. And I wonder if you could talk a little bit about why it seems, because that seems a little counterintuitive to me in many ways. It seems that it'd be more clear to title companies and other members of your association if there was certainty that when you, I'm going to use the word domesticate, but when you register a foreign judgment in the District of Columbia, that the District of Columbia 12-year statute of limitations begins to run from that date. Doesn't that give you and members of your association, if that is the view going forward with the court, more certainty rather than less certainty?
Well, it's easy to figure out what date, what is the trigger date, whether it be in the trial jurisdiction, because that's part of the judgment, that's part of the 2-page form. That's not the issue, and that's not our concerns with this case. Our concern with this case are the other questions that remain. For instance, what if the judgment is released in the local jurisdiction? What if it has lapsed in the local jurisdiction?
No, what do you mean? You mean the original jurisdiction?
In the trial jurisdiction, yes.
Well, that could be true under either interpretation of the statute here.
Well,
Couldn't it?
we know that the only court that we need to check with is the trial jurisdiction if it goes back to those the original trial date. original verdict date, let's just say.
No, that's,
However,
but that's not right either, because even if, well, under either view that the parties have taken before us, nobody's argued that, look, if this had been properly registered in DC in 2006 and then revived in 2010 before the expiration of the California judgment, both sides would say that is enforced, that remains an enforceable judgment in DC. So you're not gonna, I don't think this case presents you with an opportunity to get that kind of clarity.
well, I think the renewal question, I think, isn't entirely correct. I think if one looks to DC Code 15-101, the 12 years begins from period of 12 years from the date that an execution might first be issued, or from the date of the last order of renewal thereon, order of revival thereon. I respectfully suggest that's a reference to revival in the trial jurisdiction, because
Okay,
that's where everything arrives.
Your view is when you register, so you aren't really entitled to all the defenses. Once you've registered a judgment here in DC, you don't have the right to seek revival in the way that if you had a judgment that was rendered in DC, you would. You'd have to seek revival in the originating jurisdiction.
That, I believe, is the distinction between the two different forms of obtaining a judgment, of registering or domesticating a foreign judgment, either by registration or by new trial.
Well, how do you square that with the language of 15-352, which says the foreign judgment filed shall have the same effect and be subject to the same procedures, defenses, procedures? I mean, it seems to contemplate that whether it becomes the filed foreign judgment becomes a DC judgment or not, that language seems to push against the idea that there are special rules limiting the renewal of such a filed foreign judgment.
I don't think that rule prohibits. I don't think it prevents us from also looking to the trial jurisdiction. It says this judgment, once registered, can be defended in DC or addressed in DC, but it does not mean we can.
Well, no, I don't think that.
It doesn't mean we can address it in the trial.
That might be true, and there are interesting complications, although I thought that the two opinions for at the division stage had run through many of the complications. There seem like there's some others that about renewal or the like that really haven't been fully sorted out, but it might be true that renewal and the extent to which the judgment after it is filed, if it's, let's say, a foreign judgment is timely filed in DC in the sense both that it is, it's still not expired in the originating jurisdiction, but then as things are going on in DC, it eventually expires in the DC in the originating jurisdiction. Like what you do, whether you have to keep it alive in both jurisdictions and how that all works, that really, I don't know that we have a lot of briefing, and the division decisions didn't really get too far into those complexities.
And I think if you look to the majority decision, when the majority addresses at pages 23 to 25, their response to the dissent, all of those questions where that end with, well, it's not part of our question here, or these aren't the facts here, those issues are now raised. That is what creates the uncertainty for our constituents, for our members.
Can I ask you another question about your concern about uncertainty? It's been, I think, undisputed among the members of the division and the parties, at least, that if you go the common law route left preserved by 356, at the end of that process, you do get a new judgment in DC that then is enforceable for 12 years thereafter. So if that process remains open and has that consequence, how would the certainty that you're hoping for be achieved, however 352 is interpreted? Because there's always still the possibility that a judgment creditor will choose to take the longer route, the old route, and end up getting new DC driven deadlines that aren't so tied in the way that you suggest they are to the statute of limitations that are measured against or in fact exist in the originating jurisdiction.
We know how to deal with a DC judgment, and we know how to, a judgment under the longer version We know how to address that. What we don't know is how to address judgments under the shorter version. One
Right,
last
but
point.
the uncertainty exists the entire time that the foreign judgment is still alive until, I mean, under your colleague's view that the foreign judgment expires at some point, but until that point, the creditor can move under 356 for a new judgment in DC. So you have uncertainty for that entire, in this case, 10 years.
We're a notice. If they haven't done it, then when we're searching that title to do a settlement tomorrow, if they haven't done it, it doesn't affect us. They can get the judgment later, but property will already be moved on. One last point, if you extend out this, if you permit this to be extended for 30 years, when our members are trying to find out if the judgment was renewed or even who to find and who to pay, if it's a 30-year-old judgment, it's that much more difficult. Whereas if it's a judgment renewed recently in 12 years, 3 years, whatever, is a better chance of finding that person. We're left with judgments for years under this scenario.
Counsel, I don't see the difference. To get to 30 years, they're gonna have to have registered, they could have renewed it. Like, a lot of this complication to me doesn't seem like much of a complication. It seems like it would make it easier if we say it's one way or the other regardless. Is that correct?
It would be easier if it said one way or the other.
Can I ask you
But
also? According to the majority opinion in these, most jurisdictions around the country, several dozen at least, take the approach that the majority opinion was taking, which does allow you register your foreign judgment in a new jurisdiction and you get the benefit of the full enforcement of judgment period of the new jurisdiction. And if that is disruptive to certainty and creates real serious problems in clearing title and the like, one might think that that's something that would be case law or some information would exist that suggests it's actually been a problem in the many jurisdictions that do that. And do you have any cases or other sources of material that suggest, oh yeah, it's not just that we're kind of invoking a parade of horribles, it's hypothetical, it's that actually jurisdictions that have gone this route have had problems, and here's the evidence that they've had those problems.
I don't, and I respectfully suggest the reason is, if we have a title that is unmanageable and too difficult to clear, we will not insure that title, and we'll leave the property owner with unmarketable title, and we will not get involved to insure it, because if we insure it and there's litigation, we have to pay to defend the litigation. If we don't insure it, we stay away from it. It becomes a problem title. And
How
that
often
is
do
what
y'all not
you
insure
risk.
titles?
Sorry?
How often, do you know how often your members don't insure titles on average?
Well, every day there are decisions that are not properties that were decisions not to insure, and also decisions to clear the insurance. But I don't have, we follow based on the premiums and the titles we insure. We don't follow the ones we say, sorry, can't do business with you.
I get that answer as it might relate to why there isn't case law. I guess one might still wonder if it actually creates problems in jurisdictions that take that approach, why there aren't, law review articles or practitioner articles that say, wow, we're doing this and it doesn't work, or jurisdictions would have then enacted statutes and amended their statutes to say, this is how we thought this would, this is how we interpret our statutes, how we thought the words made sense. But in the real world, it's just creating these terrible obstacles. So we're, fixing that problem. There doesn't seem to be a lot.
We get as far, Your Honor, as underwriting guidelines that are specific to each underwriter and the risk they're willing to take in a particular jurisdiction to write that insurance or not. Some underwriters are interested in getting a larger portion of the business in that community. They'll take more risk. Others find that their defense costs are too much in that community. They won't take more risk. It doesn't get that far. And I mean, it's because it's competitive. If you know what the other guy is insuring, and you might give it a commercial disadvantage.
So I'm still not sure I'm entirely clear on the difference under either the common law route or the streamline route to the level of uncertainty to your clients and other members of your association. And I mean, on both routes, you're faced with uncertainty about the impact of a judgment, whether you go the common law route and you get a judgment in DC, the new jurisdiction, or you file in DC under the streamlined version. There's still a level of uncertainty, and I guess I'm not clearly understanding in your view the distinction and why it matters.
If we get a judgment in DC, then we have a DC judgment. We're no longer concerned what happened in the trial jurisdiction, in the remote jurisdiction. All we care about is what happened from the date of the trial in District of Columbia forward.
Right, but that is if you take the view that the streamline route doesn't result in a judgment that gives you all the benefits, rights, defenses of a DC judgment.
Well, if the streamlined version differs from the other version. The streamlined version is based on full faith and credit to a foreign jurisdiction. The more longer route is based on the District of Columbia exercising its rights to enter a judgment against its person based on, they're.
I thought both routes were tied to the full faith and credit clause by the definition of foreign judgment.
I'm sorry, I missed the beginning of that.
I thought both the 352 route and the 356 route were tied to the full faith and credit clause by the definition of foreign judgment as a judgment that is entitled to full faith and credit.
Right, and the longer process, that is full faith and credit until the time the DC judgment is entered, until it becomes an action that's entered, as opposed to a registration of a remote judgment.
I guess what I get a little puzzled by is you say, you know how to deal with the common law version that creates a like a new DC judgment that everybody seems to agree gets you a full 12 years under DC law to execute thereafter. But if the upshot of the opinion of the majority was these file judgments are the same as that in this respect, then isn't it just that you deal with them the same way? So if you know how to deal with judgments like that, the majority opinion is just telling you these are like those, so deal with them the way you're used to, rather than having a subset that is got shorter deadlines and from your perspective, I get is preferable. But in terms of being unmanageable, if you can deal with the output of 356, and if the majority opinion just says things that are filed under 352 for statute of limitation purposes are the same, then I think you've said you know how to deal with that. You just prefer not to, but you know how to do it.
If this court's ruling is that the city council issued two separate statutes for two separate procedures, but they're resulting in identical results, then we can live with that rule.
Statute of limitations, yes.
Right, but there are two different statutes. What's the impact of that? That's what we don't know. My time is long overdue, and I do apologize to Mr. Cox. I hope he'll be granted a couple of minutes back.
Yes, Mr. Cox will retain his time for rebuttal, and we thank you for your argument. We'll hear from Mr. Bradshaw.
Yes, thank you.
Thank you for the opportunity. The contortions that Mr. Russo and Mr. Cox have been forced to go through from your very basic and straightforward questions is the reason that the Uniform Enforcement of Foreign Judgments Act was created in the first place. Uniform. The point of it was unity. To have a unified way of us providing the necessary substantive.
But it's not uniform, right? I mean, the majority opinion shows that there are about 20 cases across the country that have actually looked at this question. Most of the cases that are in favor of the majority view are from intermediate appellate state courts with very little explication and side with the majority. And then there are about, so there are like 13 or 14 of those cases. And then there are about 5 cases from state Supreme Courts that share the view of the dissent. So not a lot of people are looking at this, and it's not uniform. And we're supposed to try to read the statute in conformance with the uniform view, but in the absence of a uniform view, we have to look at our own statute and figure out what it means. Don't you agree?
I respect your position, and you caused me to think when you provided your dissent in the majority position. But the point of the Uniform Enforcement of Judgment Act is unity. That's the
Right,
point
and
of
if
it.
you don't have unity, what do?
Well, we won't have unity.
Do you
for
count
it.
heads? A uniform becomes majority?
At some point, you will end up counting heads. It helps. I'm not sure what a judge like Judge Jackson may have had to do.
And when you count heads, do you look at statutes that say exactly the same thing that our statute says?
Well, I don't know if we have one that says exactly the same things that our statute.
Precisely. So then do you look at what our statute says and do you try and figure out what it means?
Sure, better.
Yeah.
That's the point
So-
of your.
So then if you're looking at our statute, right, you have 15.352 that says if you file a foreign judgment, you can enforce it in DC as a foreign judgment, right? And it's clear that it remains a foreign judgment because 353 and 354 and 355 keep talking about the foreign judgment after filing, right? It retains its essence as a foreign judgment. There's no new piece of paper that says it's a DC judgment, right? So that's one way of a judgment getting enforced in the district, correct?
I'm not sure if I should respond to you in that way. May I respond to your first proposition
Well,
to make sure I understand? you?
I'm going somewhere with this. So there's,
Go right ahead.
you do
Go
agree
right.
that getting a foreign judgment and filed, getting a foreign judgment enforced in the district can be done by filing, right?
Yes,
Okay. And it can also be done a different way, right? It can be done by initiating a suit, right? Where you get a judgment on a judgment and you end up with a DC judgment, right? You agree with that?
yes,
Right, that's what DC code 15.356 preserves. That's the old way, right?
yes.
Right, and so 15.356 says, it's interesting language. It says the right of a judgment creditor to bring an action to enforce a judgment in lieu of proceeding under this subchapter, right? In lieu of just filing the foreign judgment. That right remains unimpaired. And so I'm trying to figure out what is the right to get a judgment on a judgment? What is it that we think that the council was trying to preserve when it said, hey, you can file a foreign judgment. It remains a foreign judgment. You can enforce it in the district. Or you can get a judgment on a judgment. You have a right to do that. What do you think that right gives you?
I can't tell you, but what I can tell you is this. The DC City Council followed the model that was provided by the federal
I
government.
just want to pause, right? You said you can't tell me. Do you think that question is not worth considering?
Ooh,
You
that would
don't
be
have an
unfair.
answer? You don't?
Of course, I don't think it's not worth considering. You are considering it now. It's just that I've worked with the DC City Council and they have all manner of ways of considering every single issue and they do the best they can. Sometimes it takes case law. Sometimes it takes practical reactions to what's going on in their city to figure out what to do. I've had DC City Council.
Right, but
have-
just to put a finer point on it, the council said, there's this old cumbersome way of doing this, of enforcing a foreign judgment in the District of Columbia. You can get a judgment on a judgment. We are preserving that. You have a right to that because that seemingly gives you something, right? That maybe this new process that we are now defining with the filing system doesn't give you. Right, but we're going to let you go one of two ways. We're going to let you go the streamlined filing way, or you can get a judgment on a judgment. And so I'm trying to figure out what is it that the council thought that they were preserving when they said you still have this right that remains unimpaired to get a judgment on a judgment.
You do understand this is no disrespect intended, but I do not know the mind of the city council on that particular issue. All I can tell you is what I see in front of me. I do have a legislation that was modeled after legislation that was picked up by several states, all but two. And that was a model designed to make sure that when you have wrongdoing of a creditor, or if you want to follow that creditor to wherever he has assets, this is the way we think you might want to do it. This only started in 1990. It's not as if this is a fully blown out, and as you noted, it hasn't even been addressed with us.
Well, council, can I ask it this way? You don't have to get into the mind of the city council. I assume you represent creditors. You represent one here.
On occasion.
Okay, so when would you go the 356 route versus 352 route?
Well, I would not. That could be my lack of experience in the matter. I'm not sure, but I just would not. It does not make good sense to me. The route that was taken is appropriate. It seems as if most of the states have a way of dealing with it. The only issue is, what is that language? When does the statute of limitations
Can
begin?
I clarify, counsel, you would not go the common law lengthier route, or you would not
I'm
go the
sorry.
current, you would not take the common law route?
Yes, I'm
Which I
sorry.
think the statute makes clear that both routes are available.
They are, and but
So you would not choose the common law route, you would go the route carved out under the new uniform revised Enforcement of Judgment Act in DC. What advantages, if any, do you think it affords you, or why would you choose this new streamlined route?
straightforward. Once we've given full faith and credit to the four sister state judgment, the substantive issues are over as far as I'm concerned. I'm now dealing with procedure that I have a handle.
Meaning the
The
DC
DC
12-year statute of limitations
Exactly.
and the procedures in DC for enforcing a judgment.
Exactly. Also, I've had a chance to, DC Superior Court has had a chance to reach out and grab the judgment. I mean, I have it in my courts now. I want to use my rules to do it. And I feel more comfortable working with them. I just don't feel as comfortable going to Guam or going to California. And California is an unusual place. Anyway.
Counsel, let me ask you, what about the question posed to
I'm sorry, I didn't
your
mean it that way.
colleague also?
I did not take offense, counsel. I just thought it was just a funny phrase.
He's not from California.
Oh, I thought it was. Thank you. Forgive me, Your Honor.
What about the question posed to your colleague on the other side? That it's now been trying to think of another word. It's now been brought to DC as opposed to domesticated, we'll say. And the judgment expires in the originating jurisdiction. When DC takes over, do they now does that new statute of limitations take over, or do you need to keep the judgment alive in the underlying jurisdiction for the entire time you're seeking to keep it alive in DC as well?
To be honest, until they made the suggestion, I would never have thought I was required to go back to California and keep that judgment alive. I thought
So why does the full faith and credit, why do full faith and credit concerns then allow you to enforce that judgment here?
it might not if the judgment is not a valid judgment in California. I've already done it according to the rules that I've dealt with. Full faith and credit is, I don't have to deal with their procedures. I only have to make sure that they have had a full and fair and complete finding of the facts. They made their judgment and they've used the substantive rules and laws that they use in their courts when they do this sort of thing. And it's a good judgment. I'm going to show full faith and credit in my jurisdiction.
So in your view, this becomes a DC judgment upon that administrative registration?
That was my notion.
So why doesn't the statute say that?
I don't know. To be
But
honest.
the statute doesn't say it doesn't become
And that was my next thought.
a DC statute here, a DC judgment here. And that, I think that is the ambiguity, in my view, of the statute here. It seems to be read in context with the provisions that we've talked about to offer two paths to get to the same result of having a judgment that is enforceable in DC under the 12-year statute of limitations. It does not, in my view, which is why I said I don't take offense to the term domesticated judgment. But it doesn't say domesticated judgment, but once you register it in DC, and it doesn't say it's not subject to the provisions. In fact, it says the opposite in 352, that it shall be and shall have the same effect as other judgments. So I'm wondering if this notion of a real DC judgment or a foreign judgment that is registered effectively according to this new streamlined statute is a distinction without much of a difference.
Well, I certainly hope you come to that conclusion for my sake, but I don't know. There are some things I cannot answer. But I've studied this so thoroughly because I have to, it's the case.
But counsel,
I wish the city, forgive me.
I'm sorry, maybe you said you haven't gone under 356, but just as a matter of pure practicality, paper, if you go through 356, do you get a new document that has a Superior Court heading on it that's a Superior Court judgment? And vice versa, if you go through 352, do you not get one of those?
Well, the operative word is authentication, I believe. And yes, we get something very similar to it. We certainly have to authenticate the accuracy of the judgment that we're showing full faith and credit to. So I would make sure no matter where the judgment came from, it is foreign because it's not from us. And it is authenticated because that state followed their rules. And once I authenticate they follow their rules, that's all I do.
Right, but isn't that the point? So DC is saying, yeah, we validate this foreign judgment, and now we will treat it with the respect that it's due under the full faith and credit clause, but we're not giving you any new piece of paper that says Superior Court of the District of Columbia on it. Under 352, under 356, you are getting such a document, right?
Yes, and I don't believe it's necessary. I believe once we have given full faith and credit, we then go to the balls and strikes of the case and we manage it according to our procedures and do what has to be done.
I guess I don't understand what you mean when you say, once we've given it full faith and credit, what do you mean by that?
My understanding is that state court has followed their rules. We respect the decision. We don't worry about their procedures, but we respect their decision and we give it full faith and credit. Once it's come into our court, into our DC Superior Courts, and our trial judges have a chance to look at it, then we apply our rules to
But the
manage
trial
the
judge
matter.
doesn't have a chance to look at it upon filing, right? It's a purely administrative act. You file a piece of paper with whatever certification saying this is authentic, and the clerk's office just looks and confirms, yep, these two pieces, there's a judgment and there's an authentication. Those things are there. We're not looking to actually see that this is real. Someone mentioned in pre-conference, you could file a grocery list with an authentication and they can stamp it and say, yep, we have two pieces of paper here. And it falls to either the creditor when enforcing the judgment to say, I have a real judgment, or the debtor to take an offensive / defensive action to say, this filed foreign judgment isn't anything. It's not enforceable against me. But at the point of filing, nothing happens.
Forgive me for my silence. My first reaction was to jump right at you and say, you're missing something. But common sense says don't do that. All I can say, Your Honor, is that I haven't had experience with that possibilities argument. And that's what this entire case seems to be for me. They're talking about possibilities, what could happen. All I know is what did happen.
Well,
I
what
know
did
how
happen,
the case
counsel,
was-
the record's really murky here. And, equities abound in trying to enforce a judgment, in my view. And so perhaps you could start with what the heck happened between 2009 and 2014, when apparently there was an execution available for the property and it didn't get sold that led to this whole situation. And then we can go from there.
Well, I'll try to do it from my brains. There's a probate matter. The original debtor died. He, as a resident of the District of Columbia, and the property being District of Columbia property, there was a complaint and a claim filed in the probate. His son came to process the
Counsel, if I could stop you though.
yes, ma'am.
Mr. Wilson didn't die until 2016.
Well, oh, okay, only that one, that
So
period.
there's a judgment, right? The foreign
Let me
judgment
make
is filed in 2006. There's a request for a writ that is granted in 2007. There's a request for a stay that's denied in 2007. There's an appeal that's resolved in 2009. And I saw in one of the trial court filings what I view to be a concession by HDA saying we ceased pursuing this for some period of time.
Well, all but the last statement, I thank you for reading that. Let me make sure I understand. You're concerned about the time between 2014 and 2016 when the,
2007 to,
oh, okay.
I mean, I would say 2013 when the judgment arguably expired if you date it back to 2001, if you start the clock, the 12-year clock of 2001.
There was a
So even
bankrupt-
if under the limited time period of starting the clock at 2001, from 2007 to 2012 is 5 years when seemingly no definitive action is taken to acquire the property. I think
Did
the
you say
statement was, and it was made in the 2017 memo in support of the motion to revive the recorded judgment, that HGA ceased execution against the property and the matter remained dormant for some time.
To make sure I understand, is that the period of time when there was a bankruptcy?
I don't believe the bankruptcy began until later, but you can correct me if I'm wrong.
I can't at this very statement, at this very moment, but I believe that could have had an impact. I want to make sure I don't miss Judge Howard's initial
Our
question.
questions are intertwined, counsel.
They are.
record is
The
murky for me.
bankruptcy proceeding begins in 2014. Mr. Wilson dies in 2016. And I'm particularly interested in the time period between 2007, when the writ is issued and the stay is denied, and 2014. I mean, 2012, 2013.
And in your
Sorry.
brief, there's some somewhat vague references to the possible obstacles created by a homestead exception, but maybe you can shed it. I found those somewhat broadly worded, so I don't know if as you stand here now, you could be more specific about when that arose or what was determined, if anything, ever about the validity of those assertions or the consequences of those assertions.
Thank you for saying the word homestead. I was not the attorney who initiated this matter. I have read the circumstance. It was another attorney. I didn't remember everything, but I read it carefully. The homestead, we believe, was a reason to stay the action on the property. Because it was considered to be his homestead.
Was that ever litigated?
I don't know that was in fact litigated now. I can't respond to you, but I will
Because
say.
in the appeal of the writ that was resolved in 2009, this court said that some mention of the homestead exemption had been raised for the first time on appeal, but had never been litigated in Superior Court. And I didn't see anything in the record of this court that Mr. Wilson ever litigated a homestead exemption. Or that HGA ever tried to say there is no, we want to move forward on that. We have a writ, there's no stay. And we don't believe the homestead exemption applies.
Well, I do know they did believe it did apply, but I don't know that there was litigation or final response to that question.
Well, if HGA was wrong that the Homestead Act would have precluded them from executing on the writ, then isn't that something we should take into consideration?
And you will, but the question goes back to the initial question of when should the statute of limitations begin to run?
Right, but when it begins to run and also when I think there was some suggestion in the briefs that the homestead exception served to toll the statute of limitations. I don't see anything in the statute that says that, and it wasn't ever litigated.
still, and I understand, and I'm searching obviously to give you the response that would make it a clear cut for you. But what I can say is the question becomes and remains, should we have been dealing with the date the judgment came into the District of Columbia and then to these courts? Or should we go back to when the judgment happened in 2001? Because that's when the statute of limitations began to run.
Counsel,
we are still
I
within the
have
statute
one
of
more
limitations.
homestead question for you. I'll show you half of a card of mine. I actually practiced this type of law for a little bit in a foreign jurisdiction. And my homestead question for you is, are you aware of any of the practicalities of the practice? For instance, in Texas where I practiced, that didn't have to be litigated. If I brought a writ of execution to a constable and sought to execute on property, they would just check the tax records for which property was designated as homestead exempt, and that property was free and clear. I could not touch that without a court ever looking at it. Do you know if we have a similar process here in DC? No, you do not know, or no, we do
No, I
not
do
have such a
not know.
process.
And I believe I could find out if I knew I would have that question to respond to. But I have to be honest and stand with what I have.
So for that 2007 to 2014 time period, it is your understanding that it is possible that homestead was what held up pursuit of this judgment in this individual
I know
case?
that's exactly what was said. I'm saying my limits on my understanding of it are in question. But that's exactly what the explanation that was given is. The homestead exemption was the reason that it was delayed. I know that, but that doesn't help you. Well, I
I'm
hope it
sorry,
helps.
can I ask also another question? I mean, the homestead exemption just precludes the marshal service from seizing the property, right?
Yes,
What effect, if anything, does it have on the judgment?
the foreign judgment,
Or even a DC judgment?
I don't know. It has no effect on the foreign judgment. It's here. We're just enforcing it on assets in the District of Columbia, on real property in DC.
I assume that if you had run up against that, if that was the real obstacle and there was a concern about timing, it would have been available, perhaps at least to try to renew the judgment, either in California, if you think that needs to be done, or at least under the provisions allowing for renewal of judgments in DC. But that wasn't an option that, as far as you know, was considered
It
as a
wasn't-
way of avoiding a statute of limitations issue
Well, I
that one could
appreciate-
see coming.
I appreciate the way you placed it. Yes, of course. If I had known that there was a problem, we would have addressed it differently, but we were within the statute of limitations as we understood it. And we were fine. We had time to do what we had to do.
All right. I don't know if there are any further questions from the panel. Is there anything you'd like to say in concluding your argument today's council?
Well, yes. I had a lot to say, but you guys straightened me out on that. I will say the following. My headline was the following, and it came from majority opinion. It appears that every federal court of appeals that has decided the issue has held that registration of a judgment at a new district court pursuant to section 1963 triggers a new limitation period for the enforcement of the judgment, measured from the date of registration rather than the date of the original issuance of the underlying judgment. That's essentially a quote.
Let me ask, can I ask a question about that? I will ask your opposing counsel on rebuttal, but the federal statute is similar. It's 1928 USC 1963. Is it identical to our DC Uniform Enforcement of Judgments
Not
Act?
to my reading, no, but it is, DC has so much, the federal government has so much impact on what we do and don't do, that it is appropriate to use it as a tool to understand what we mean when we look at our language.
Does the full faith and credit clause apply to the federal government?
Ooh.
I
Full
don't think
faith and
so.
credit card. The federal government doesn't have sister states. I'm not quite sure how you mean that.
Right. So 1963 is addressing an issue about enforceability of federal court judgments in different districts,
Yes.
but it is not inspired by or fulfill the purpose of providing full faith and credit to sister state judgments, correct?
Well, may I respond as I want to? I'm a citizen of the District of Columbia. The federal government makes us have emergency legislation to pass new laws about DUI laws. They have so much impact on what we do that I would always go to the federal government to find out what they mean before we get a chance to apply our laws. So I'm accustomed to using the federal government's language. I'm just accustomed to it. Right or wrong, I'm accustomed to it. I don't like it. I'd rather have statehood, but that's my problem. The other part of this is, it's not just the federal government that said that. My second part of my headline was, daggone it, a majority or weight of the state courts also ruled in this fashion. And all we're really talking about is alternative interpretations of the rules. An alternative interpretation, if it's reasoned and well thought through, is not a basis for reversible error. So I think I'll close out and hope for the best.
Thank you, counsel.
And I do have a lot of time left just in case I have to.
Well, if you have additional time and arguments that you want to make, you're welcome to use your time, because typically we wouldn't have rebuttal or.
You know something, I think I might as well take my hand and sit. Thank you.
All right, thank you. Mr.
How
Cox,
much time am I allotted?
I think you had about a minute left on the clock, but
All right, so very quickly, going back to the point Judge Howard, or the question you raised. Yes, it's inexplicable why nothing happened after the writ was issued. In fact, when you look at that 2009 appeal, I think the appellate court was under the impression that it had been executed upon. But actually it never was. No action was taken. And bankruptcy wasn't filed in 2000 until 2014, which would have been after the expiration of the statute of limitations. So
My understanding is that Mr. Wilson did file something in the Superior Court saying that he was subject to a homestead exception.
right,
And granted, that wasn't litigated, and I don't see it necessarily being relevant under the statute, but certainly he might have prompted HGA to think otherwise, right?
well, I don't think if I was the creditor, I'd just be sitting back and finding out, right? I mean, they had an opportunity. If they wanted to litigate it, they could. Ultimately, they went to the bankruptcy court and they learned from Judge Teal, their lien was utterly unaffected. And that's true even under the homestead exemption. Your lien isn't the least bit affected by a claim of homestead. And if you want to litigate the homestead, particularly when somebody's in bankruptcy, you go ahead and file your motion before Judge Teal or.
So what happens in that instance? I mean, this is a little bit off topic, but the homestead exemption is DC Code 15501, right? And it prevents seizure of the asset, but what would a creditor do in that instance?
In this instance, especially since he'd filed bankruptcy, I would have been filing a motion.
Before he filed bankruptcy, right? Because presumably, I mean, I didn't see any filing of a homestead exemption in the record, but let's say that he had, and he did so soon, after the 2009 decision from this court upholding the writ. Then what? What should the creditor do?
Then file a motion for relief from stay in the bankruptcy court. If it's pre-bankruptcy, go ahead and file a motion for clarification with the Superior Court that am I really precluded from actually executing on this particular interest in this particular property.
And say the Superior Court says, yes, you are. He's entitled to the homestead exemption. Then what of your foreign judgment or your DC judgment even?
You can't enforce it at that time.
But it still remains
The
live.
judgment still remains live.
And
In fact, the statute makes it, a claim of homestead doesn't toll the running of the statute of limitations. So, there was no, they needed to move on that if they really thought that was a concern.
Right, but if they thought that it was a valid claim of homestead, which I mean, are you contesting that it was a valid claim of homestead, or you just don't know?
I don't know if it was or.
I get that. I can see why you wouldn't know. But if they thought it was valid, then they can't seize it. That you agree on. And from your perspective, what they should have done is realize the statute was running and taken some measure, like maybe renew it if they can do that, keep it alive in California. So there are things they could have done when they ran up against that obstacle.
There are things that the creditor could always
Right,
do.
but none of them, I think, would have been go to the Superior Court and try to litigate the validity of the homestead exception if they believed it was valid. Because why would they do that?
Well, if it was filed in the bankruptcy court.
I'm pre-bankruptcy. That's a whole other complication.
Pre-bankruptcy, then even assuming it was filed, I mean, you're right, the record is actually not clear that any such homestead claim was asserted, but even assuming it was, then you just can't sit back and wait.
No, I get that from your perspective, they should have, been, but I just am not sure that one of the things, if they thought it was valid, I'm not sure one of the things that they should have done was go and litigate its validity if they were not disputing its validity. I get your point that if the clock was going to run on them, there are other things they
Yeah,
need to do. That I get.
if they're conceding that it's valid, then that's their call.
So they just go and keep the judgment alive.
Yep.
I have one more question along these lines. So, and I get and I understand the point of perhaps it's that from your view and perhaps from the title loan company, the title insurance company's view, when they did the record check on the specific sale, the lien had expired. But I'm a little bit confused what happened to the original judgment lien that was created when it was recorded. If that was still there and the bankruptcy did nothing to it and that was on the books, how the heck did they manage to sell the property? Not once, but twice.
Yeah, well, there are two possibilities. One is they missed it in their title search, right? That's a possibility. Secondly, though, is if they looked, they would have read the DC law and said, okay, this has expired. There was the California judgment, 10-year statute of limitations is run. Even if we look at the recorded California judgment in DC, that 12 years period has run, done.
Or
And-
they could have looked at the statute and said, well, we filed under the Uniform Enforcement of Judgment Act in DC, and we have a new 12-year period of statute of limitations subject to DC rules and regulations, and maybe missed going back to look at California judgment
Right.
at all, thinking that that was not needed.
But but I think the way that underwriters typically have looked at this is they're looking at what was the date on which process could have first issued in the rendering court.
Well, that's the
And that-
question for us.
Well, it is a
today.
question, but you're asking me the question, why would the title company proceed? That's why.
Because you're saying that if they thought that the 12-year statute of limitations restarted upon filing, they would have flagged it.
Correct.
Yeah.
Right. I mean, frankly.
I mean, they
we just
could have
didn't read
messed
it that
up,
way
but-
before the
right.
Majority decision, but I'd like to, I know I'm well over my time. So let me just say, I think that, in our view, if you have to look at the plain language of this statute, that language in our DC code about when you can first obtain process means something. And I know it should mean that time began to run in 2001 when the California judgment was rendered. And I don't think we should take the DC Council legislation and act as if they didn't really mean to keep two separate statutory schemes in place. They did. They left to the creditors the opportunity, if they really wanted a DC judgment, there's a perfectly good means, and it's not that difficult to get, and they could get that. But they also, if they want to just have the, again, for full faith and credit purposes, the ability to execute that judgment here in the District of Columbia, but keeping in mind it's still a California judgment, then that's true too. So I would ask the court to reverse the trial court's decision and enter judgment in favor of the appellant. Thank you, Your Honors.
Thank you.
It's been a pleasure.
We
Thank you.
thank all counsel for your briefs and arguments today, and cases submitted to the court for further consideration. Thank you.
This honorable court is now adjourned.
Take care. I do know it.
Let's know in a couple months. For years.
I hope that, that's the mission.
I know. I just